Most Americans believe the Constitution guarantees their right to vote. Speech, assembly, religion. Each right is explicitly named and protected. The right to vote is not among them. It never was.
Philadelphia, 1787. 55 delegates convened to design a new government.
Suffrage was debated extensively. The framers held deeply conflicting views. Property qualifications, race, sex. Each state would set its own rules. The framers made a deliberate choice. Voting would not be federally defined. Article 1, Section 2, offered only a narrow, conditional framework for elections. States were granted authority to determine the manner of their own elections. 13 separate voting systems. 13 separate definitions of who qualified. No uniform standard. No constitutional floor. No guaranteed right for anyone. That structural decision would echo forward across 2.5 centuries.
For millions of Americans, the right to vote felt absolute and permanent.
It was treated as a birthright. The law told a more complicated story.
Civic education taught the right to vote as foundational American identity.
Communities organized around the assumption that their votes were protected.
Polling stations became civic temples. The act of voting, a ritual of belonging. Each ballot cast in the belief that the system existed to protect the act. When that protection was removed, the absence was felt before it was understood. The community's assumption had no constitutional foundation behind it. State legislatures have always held the primary authority over voting systems. New voter identification requirements were introduced across multiple states simultaneously. The language was facially neutral. No mention of race. No explicit restriction. Facially neutral laws carry no discriminatory language on their surface text. Civil rights attorneys recognized the pattern before the data confirmed it. Documentation began. Counties with higher minority populations faced steeper restrictions. The data revealed a correlation the legislation's authors never acknowledged in writing. Attorneys worked through the night, mapping the law's disparate impact by district. The numbers were irrefutable. The mechanism, however, would be harder to prove. Building a constitutional challenge required more than statistical evidence alone. Constitutional law provided limited tools. The text offered narrow grounds for challenge. Attorneys returned to the foundational question: what does the Constitution actually say?
To choose. The transcription should only contain the spoken words provided in the narration_dialogue, since it is
The right to vote appears nowhere as a positive, affirmative constitutional guarantee. What attorneys found was not a loophole. It was the original design.
The 15th Amendment ratified in 1870. Its language carefully examined.
Shall not be denied. A prohibition, not an affirmative grant of the right itself. The 19th, the 24th, the 26th,
Each follows identical structure. The 19th Amendment extended the prohibition. It did not create a new right. The legal distinction between a prohibition and an affirmative right is not semantic. Harper versus Virginia Board of Elections, 1966. The court addressed voting directly.
The court called voting a fundamental right. But fundamental does not mean absolute.
Fundamental rights remain subject to state regulation under carefully defined standards. Bush versus Gore, 2000. A per curiam opinion the court itself called unrepeatable. The majority explicitly stated the ruling had no precedential value beyond itself. A Supreme Court ruling on an election, explicitly designed to establish no legal principle. The evidentiary record assembled across months of constitutional research was substantial. Shelby County versus Holder, 2013. The Voting Rights Act's enforcement mechanism dismantled. The court struck the formula used to identify states requiring federal voting oversight. Within hours of the ruling, states began altering voting laws without federal review.
The correlation between removed oversight and new restrictions emerged within months. Statistical analysis documented the acceleration of restrictive measures post-Shelby. Polling location reductions, stricter identification requirements, shortened voting windows, each measure legal in isolation. The cumulative architecture told a different story. The evidentiary foundation was complete. The constitutional paradox now fully documented. Federal litigation challenging state voting restrictions advanced slowly through the courts. Plaintiffs argued that facially neutral laws produced unconstitutional discriminatory outcomes. The legal standard for proving discriminatory intent is extraordinarily high.
Courts applying Arlington Heights required proof of intentional discrimination.
Village of Arlington Heights, 1977. The standard that would govern discriminatory intent claims. Proving intent required evidence the legislature consciously targeted a protected class. Statistical evidence of disparate impact alone was constitutionally insufficient. The paradox crystallized in the courtroom. A right without protection is not a right. Courts were asked to protect a right the Constitution never explicitly established. Lower courts split on the standard applicable to neutral laws with discriminatory effects. The Voting Rights Act, Section 2, offered some protection. Shelby had weakened its reach. Section 2 prohibited voting practices resulting in denial based on race or color. Results-based challenges faced renewed legal uncertainty in post-Shelby jurisprudence. Appeals accumulated, each circuit interpreting the constitutional gap differently.
A circuit split is a constitutional invitation. The Supreme Court would eventually respond.
Certiorari granted. The court agreed to hear the question of state voting law standards. The constitutional paradox had reached its highest possible legal venue. The court faced a foundational question the framers had left deliberately unresolved. Equal justice under law. A declaration carved in stone above an unresolved constitutional silence.
The oral argument would force the court to confront the text's most consequential absence.
Justices pressed both parties on the distinction between prohibition and affirmative right. No justice denied the gap existed. The debate centered on whether courts could fill it. The decision, when it arrived, would confirm what the constitutional text had always said. The majority opinion confirmed the structural limitation. No affirmative right existed. States retained broad authority to structure their electoral systems within constitutional limits. The dissent argued the court's interpretation left millions constitutionally unprotected. The dissent warned that the absence of a floor meant states could erode access indefinitely.
Civil rights organizations immediately assessed the ruling's operational consequences.
Post-ruling, 14 states introduced new voting restriction legislation within 90 days. Each piece of legislation was structured to survive constitutional challenge on its face. Facially neutral, disparate in documented effect, legally defensible under the existing framework. County election administrators received new directives without federal pre-clearance review. New polling location requirements took effect before the next scheduled election cycle. Reduced locations meant extended travel distances for voters in specific demographic districts. The accumulation of individual restrictions created a structural barrier not visible in any one measure. Legal scholars began examining the ruling's long-term implications for democratic architecture.
Constitutional scholars distinguished between rights that restrict government and rights that guarantee access.
The United States Constitution, as written, contains only the former regarding voting.
Comparative analysis revealed 53 nations with affirmative voting rights in their constitutions.
The United States remained a constitutional outlier among established democratic nations. Reform efforts introduced in Congress gained minimal traction against structural legislative resistance.
Constitutional amendment proposals require two-thirds approval in both chambers of Congress.
Each previous proposal to establish an affirmative voting right had failed to advance. The constitutional gap identified in 1787 remains unresolved in the present day. Modern voting restrictions continue to advance through legislatures across the country. Requirements vary dramatically by state. No federal constitutional standard establishes a baseline. Active litigation challenging restrictive voting laws continues in multiple federal circuits. Courts continue applying standards developed without an affirmative constitutional right to anchor them. The constitutional question remains open. The text has not changed. The gap has not closed. 237 years after its ratification, the Constitution's silence persists. The document is preserved with extraordinary care. The gap within it is equally preserved. Scholars continue to examine the structural choices made during the Constitutional Convention. The framers understood what they were choosing. They chose state authority over federal guarantee. The ballot exists. The legal protection for the act it represents does not. The right to vote is foundational to American democracy. It is not foundational to American law.